everything stated in this video is my opinion and my opinion only. And just like everything else in these cases we discuss here on this channel, everything is alleged. I don't know if some of these have like corrected themselves yet. Some of these I tried to open earlier and it wouldn't let me open them. Like the pictures of the victims, are they working yet? Okay, earlier these weren't working. I was getting some sort of error message when I was trying to open some of these. So I'm glad that they're working now. So we'll go through them as they are newly new. Now, we went through some of these, like the guilty plea advisory, the ones that are old, and now like once like new stuff gets put on here, it takes away the new rectangles for like the ones that were posted the day before. Yesterday, I did notice that 2 other ones became unsealed, but they were like orders to seal things with like 4 sentences with no information. The shit should have never even been sealed. It was crap like that. And I honestly don't even remember which ones they were now, because it was just so stupid, like unnecessary. Okay, so we're going to start from the top. And we're just going to open these. These are the photos that they submitted. I don't know why they felt the need to put such a dark filter on these. Like, this is proof right here that the state unnecessarily puts filters on shit. This one looks sort of the way, yeah, this one pretty much looks the way that it looked whenever we first saw it on social media. But like this one looks edited. I saw this picture yesterday when I was trying to get the thumbnail together for the video I posted this morning. This one definitely looks like they put a filter on it. They definitely put a filter on this picture. I love how white her hair is. I used to do my hair like that. And then Maddie's. Yeah, this one looks like a little bit different than the one that we've seen before. It just looks like they put like darkening filters on them. And I really just don't know why. I don't know why. So then we have the no contact orders, but we pretty much like know who these are for. One name is missing, which I found kind of interesting. And it can't be because, oh, maybe she doesn't live in this area, because Bethany doesn't and hers is in here. So we'll go through these and then I'll tell you which one is missing if you haven't noticed by the time we're done here. This one is for Bethany. Then we have the second one for Karen and Scott. So for Maddie's mom and stepdad. Number 3 is for Jeff and Jasmine. Kernodle. And then we have the 4th one, which is for the Goncalveses. I don't know if Steve Goncalves is number 3 or if this number 3 is actually Steve Jr. I don't know. I don't dig enough to honestly care what their middle names are or who's in order. This is the only time it mattered to me, because we have Christy, we have Autumn, we have Aubrey, we have Stephen Anthony Goncalves III. Is that the junior or is that dad? Because then we have Linda and then we have Cheryl. This would be Christy's mother and this would be Steve's mom. But I don't know if this is for Steve Jr. or if this is for Steve Goncalves. You would assume Steve Goncalves, but the grandparents are on here as well. So I don't know why the brother wouldn't be on here. Ika is saying it's Junior. She's not going to have one. Yeah, Olivia is not on there either. So this is Junior. So this is Junior. Okay. 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 So then we go on. I think, is it this one or is this the one we just opened? Okay. So then we have the Chapins, Stacy, Jim or James, and then Hunter and Maisie. And then here's the one for Dylan. Right here. And then we have the last one, which is for Ben Mogen and his wife. And then I think I can't remember which is which, honestly. Isn't Corey the wife? Corey's the wife. I don't remember who Kim is. I think the mother, the grandma, maybe. And then Bella. There's not one for Kara. There's not one for Kara or for Jasmine and Xana's little brother, which they've never put his name in anything. And maybe because he's got a different dad than Jeff, I'm pretty sure that that's with her ex-husband, Randy, is the boy's dad. I think. Again, I don't really dig into all their like genealogy that way. So I'm just kind of going off of like the skimmed information in my brain and some of the stuff that Kara's told me. But there's not one for Kara, which I found interesting. There's not one for Kara. Okay, so the next one that we have that's new is this second notice of filing when it comes to the jury questionnaires. Now, again, we're not having a trial. The questionnaires, there's really like nothing about any of this stuff that's relevant to what's happening right now, but I still wanted to go through and see what they were objecting when it came to the questionnaires. This is the defense team giving some objections, and this is for the questionnaires received in court on June 18th, 2025. So question 50, the defense requests that the question include the below additional language. If the defendant is found guilty of first-degree murder, is it possible that the jury will have to decide whether or not to impose life without parole or the death penalty before the jury? So they wanted this verbiage placed in there. Question 53, the defense requests that the question include the below additional language in section D and G. While I generally favor the death penalty, I think I can make this bigger. Okay. While I generally favor the death penalty, I can vote against imposing it if the state has not met its burden of proof that the death penalty should be imposed based on the facts, or if mitigating evidence presented convinces me life without parole is appropriate. Law and judge's instructions given in the case. G would be, while I generally oppose the death penalty, I can vote to impose it if the state has met its burden of proof that the death penalty should be imposed based on the facts. No mitigating evidence convinces me life without parole is appropriate. Law and judge's instructions given in the case. So they wanted both ways put in there, that you can vote against it and that you can vote for it. That's interesting. Okay. Question 55. The defense requests that the question include the following additional attorneys: Ingrid Beatty and Madison Allen. Okay. Question 61. The defense objects. The coverage of this case has been pervasive. It is in the media every day. It is. There has been a lot of misinformation throughout the pendency, and any prospective juror that has read, heard, or watched the coverage cannot set aside what they have read, seen, or heard. Exactly. I don't give a shit. I don't care that a judge can be like, strike that from the record. Jurors, you need to ignore that. Do not consider that. You can't unring a bell, broski. It doesn't matter how many times you say that. You cannot unring the bell. Once it's out there, it's out there. It just is. You can't do shit about that. Bias runs deep and strong depending on many potential connections to the case or to stories read, seen, or heard. The change of venue was granted for this reason. That's true. Question number 62. The defense requests that the question be reworded to include the below additional language. If you do not hear evidence during trial matching what you have heard from media or other sources prior to the trial, or hear evidence that differs from what you have heard from sources outside of trial, how will that impact the evidence presented during trial when deciding about the case as a juror? I mean, that's honestly like a really good question, because everything that the media has come out with doesn't really have much documentational proof behind it. That's just fact there. That's just fact there. It just really don't. Okay, I think that's it for that one. Okay. Ooh, yeah, leave. Okay, so now we have, whoa. Okay, is this the one about what's her face? Yeah, okay. So the defense's 24th supplementary request for discovery was all about good old Molly Marie. Isn't that so interesting? Copy of all arrest reports, charging documents, and videos for Molly Marie McMichael from June 1st, 2022 through May 31st, 2025. So before the murders, which is interesting. Copy of all email communication between the Goncalves family their attorney or representative, and the Latell County Prosecutor's Office relating to Molly McMichael. Oh, I can just about imagine that the second that body cam footage came out of her saying something, they were all over that. Probably even more so when she turned to Payne's body camera and was like, I'm friends with Bill Thompson. Yeah. Oh, I'm sure he was. I'm sure Steve was on it. Copy of all email communication from the Latell County Prosecutor's Office and law enforcement and or other agents relating to Molly McMichael. Any updated supplemental reports and or recordings of interviews conducted by law enforcement with Molly McMichael. What I don't understand, though, is why are you just now asking for this stuff? Because, like, what's the date for this? Do they even have a date on this one? They don't even have a filing date on this one. So let's look at the next one. So this request was submitted 6/25/25. Why are you just now asking for this? You didn't automatically like run a damn background check on this person that was supposed to be a witness in your case? Wouldn't that have been like a day one situation? Why are you just now looking into this? I don't really quite comprehend that right here. I feel like if the defense team was worth a shit, they would have had this a long time ago. That's just my personal opinion. So we have Exhibit S-1, State's response to defendant's 24th supplemental request for discovery, Exhibit W filed on 6/25/25. The state's responses are provided in blue. The state will continue to supplement its discovery responses as additional information is received. I wonder how Bill Thompson felt about her freaking remark. She probably, for some reason, thought that he would just like never see that. I want to know, like, how come none of these people that Bill Thompson has interviewed with has asked him about his friend Molly? I would have. I would have. Copy of all arrest reports, charging documents, and videos for Molly Marie McMichael from June 1st, 2022 through May 31st, 2025. I hope they ask Washington for the same shit, but again, they should have had this a long time ago. The state has complied with the video portion of this request and has provided the following, and this is the number, video cam from 9/4/24 and 9/5/24. 7/7/25 was the date that it was discovered. Bullshit. Isn't that like the videos that Plunder and Christy Nevada put out like a long ass time ago? The state has requested the balance of this request and will discover upon receipt. Copy of all email communications between the Goncalves family, their attorney or representative, and the Latell County Prosecutor's Office relating to Molly McMichael. The state has complied with this request. The state reserves the right to object to further disclosures that are outside the scope of the above request pursuant to ICR 16.3G. The state has provided the following. Email from Steve Goncalves, 6/19/25, and email from Shannon Gray, 6/16/25. So Shannon Gray was on it first, and then here came Steve. I need to go back and see. I want to see something real quick. When did Plunder put that video out? Because I'm pretty sure she was the first one that put the video of what's-her-face saying the lies. The absolute freaking lies. Let's see what date that was. Because remember, all these body cams and shit came out and her telling Payne that she was friends with Bill Thompson before we had a plea agreement. This and the alternate perpetrator stuff came out, and then all of a sudden everything went freaking left. Let's see. It wasn't 2 months ago, was it? So this is this DoorDash camera. Okay, right here. I parked right next to Bryan. Here it is right here. What's the date on this one?
Seemingly like
June 14th, 2025. So 2 days later, Shannon Gray is messaging the state and asking what the hell is going on with their information. And Steve is messaging them 3 days after that. Okay. So yeah, this whole like date discovered bullshit. There's no reason why whenever they are having someone come in and testify that they are not running background check information off the jump. Both sides. Why the state and the defense are both like, oh, we just found out about this. How? Whenever you called her to be a witness. How? Aren't they supposed to look into all that shit? This is just so stupid to me. Like, how is this reality? Because this is not normal. This is not how this is supposed to work. Copy of all email communications from the Latell County Prosecutor's Office and law enforcement and or other agents relating to Molly McMichael. Hold on, I need to change my banner real quick because it still is talking about the other thingy bobber. Okay. Yeah, I don't see how they wouldn't have had this already. State has requested this information and will discover upon receipt. Okay, well, they don't want to give any more information about emails about her. I'm sure there's a lot, especially when it comes to like the lie of a story, considering that everything that they have in the report is that she didn't see a white car, she saw a tan one. And they're trying to say that some car pulled in right behind her, but she don't know what the hell they're talking about. So it's amazing how it went from she didn't see anything to I parked next to him because the freaking cops told you that? Because the cops said something crazy to you that you don't even know, that you know actually to like not be true, and you're just sitting there like going along with it because you're a paid snitch? Tell me I'm wrong. Highly doubt it. Okay, so this is where they talked about the alternate perpetrators a little bit during court. These are like the court minutes from 6/18/2025. I'm only going to read up until all of the redacted stuff right here, because the rest of this is just about how they were going to handle trial when it comes to cameras, camera angles, still photography, a sketch artist, stuff like that. If y'all want to go ahead and read all the rest of that, because I'm not reading that stuff here. Here you go. Did it not post it? Okay, there it is. Here's the link. So I'm only going to read like the parts up until that, because the other stuff is like, who cares now? We're not having a trial. Cool. There might have been a sketch person. Cool. Awesome for them. Okay. The judge says, we are here for the alternate perpetrator argument. After would like to discuss the concerns/demands that have been made related to the so-called investigation, and then just some trial miscellaneous stuff. Let's start with the alternate perpetrator arguments. And then Massoff says, we have submitted material in briefing, so unless you have specific questions, I don't know that there is that much difference between the state's position and our position. Does the court have specific questions? And the judge says he doesn't. Then Massoff says, my understanding of the state's position is if they don't have a problem with us confronting this evidence, and to the extent that we do not, and to the extent that we do that throughout the trial, we will do that step by step. If there is a development by the end and we could ask the court for an alternate perpetrator instruction, we will discuss that then. We have absolutely no intention of using those words in an opening statement. Then the judge says, let's find out what the state's position is. I too was curious in their briefing as to the statement they have no objection to confrontation and cross-examination, which of course they have, but then the question becomes scope. Why is this in a completely different font? What did they have to change here? And this so far is sounding like the state was okay with them doing some sort of alternate perpetrator questioning, right? That part right there makes it sound like the state was okay with it. So then Thompson says, I think we may be dealing a bit with an issue of semantics. State views alternate perpetrator evidence as being a very defined category. Defendant will argue that he didn't do it and that this particular person did. Defense does not have factual basis to make that kind of argument. They have provided general information that they might ask investigators about to deal with the scope of the investigation, but not to the point of justifying them pointing to a particular person, saying that that's an alternative perpetrator. Looking at the defendant's most recent filing, response to the state's objection, there is mention about the defense's theory that there might be more than one perpetrator. That is not alternate perpetrator evidence. They are welcome to cross-examine the scope and the quality of the investigation, but they should be directed that they cannot focus or direct the jury to say this other person or this other person is the person who committed these crimes. Then Massoff states, I want to clarify two reasons why there was a statement about there could be more. One being that we have not looked at all of the tip evidence that is coming in, which is just a ginormous amount. It's been almost 3 years. To me, that's just laziness. Like, it's been 3 years. Okay, we wouldn't just surprise you. We know you don't like surprises. When it comes to the other thing with regard to numbers beyond 4, I think that the court has seen in the exhibits the number of people who have been examined for DNA. There are some people whose DNA was extracted and comparisons were made, and there is a whole other group that are on those state exhibits where the DNA samples were taken but were never developed into an extraction for comparison purposes, like the blood sample on the glove and the blood that was found on the stair rail between the first and the second floor. Also, names I think we will know if they developed over the course of the case and how people are coming in, whether it's in the form of initials or if it's in the form of names, or if they are putting these people they have listed on the stand and it's very clear what their names are. We'll have discussion of what's fair game in closing argument. I will leave it at that. Then Thompson says, what Masoth just said is exactly what we are concerned about and why we ask the court direct they make an appropriate proffer to justify whoever they want to claim is an alternate perpetrator. To take the position, if they develop during trial, defeats the entire purpose of the motion in limine and leaves it wide open and just subject to attack or ambush during the course at trial. We believe that is not appropriate. This is sort of like following the theme that we've heard the whole time, that they were going to use the state's evidence against them. It's sort of like matching that theme here. This is the judge. I did give a deadline for the alternate perpetrators to be identified and developed. Apart from whatever my ruling is with regard to those 4 individuals, anyone else, it would have to be before anything is brought to the jury and be an extraordinary showing of good cause as to why it was not brought to the court's attention prior to then. I would have to look at all of the relevant factors, including prejudice at the point of the state for not having brought that forward in light of the deadline set by the court. I suppose during trial, if somebody confesses, that's a different situation. I am not holding out hope or belief that that's going to happen, but I suppose you never know. I want to be clear. I will issue a ruling, but I'm going to tell you that I don't find the defense has submitted anywhere near sufficient evidence to get beyond rank speculation that these individuals were in any way involved in the crime. And then a bunch of redactions, and then states, but that is nowhere near tying them to the crime itself. So we have no idea what this says. And this context is, I don't know. It's just not enough. The reason I wanted to have this hearing and the reason I wanted it sealed is because I'm not inclined to allow counsel to go out and try to destroy reputations of people without any foundation to do so. Before there is any suggestion to the jury that a specific named individual was involved in this case, I better hear about it first. Defense is entitled to cross-examine about the scope of the state's investigation and the thoroughness of the investigation and the reasonableness of the investigation. Certainly, questions may potentially come about why didn't you do this and why did you do that from the officers. Where we may get more tenuous is when we start getting into collateral information about individuals. I can understand that a claimed motive might be important as it relates to the reasonableness of the investigation, provides examples. I want to be careful if that is offered at all. And then just a bunch of this. They go back and forth. They talk specifics about probably each and every person that they're discussing, and then it just goes away. It just goes away. And again, all the rest of this just talks about like how they were going to handle the trial dates, the schedule. Yeah, that's all this is. Where they were going to put the camera people so that people like couldn't, look at their computers or see anything that was on the screen. Yeah, there's really nothing else here on this one. Okay, so then we have the defendant's reply to state's objection for defendant's offer of proof regarding alt perpetrators. 6 pages. Let's see how much information is in this one. Let's see if I can make this bigger. Okay. Okay. Comes now, Bryan C. Kohberger, by and through his attorneys of record, and hereby responds to the state's objection to defendant's offer of proof regarding alternate perpetrators and defendant's evidence in support of offer of proof of alternate perpetrator filed June 6, 2025. Whether rooted directly in the due process clause of the 14th Amendment or in the compulsory process or confrontation clauses of the 6th Amendment, the Constitution guarantees criminal defendants a meaningful opportunity to present a complete defense. Well, we saw that not be true in Delphi. So there's that. Then they cite Crane versus Kentucky from 1986. The error excluding such evidence is reviewed de novo on appeal. And then U.S. versus Shryock from 2003. Due process rules trump evidentiary rules. And then they cite U.S. versus Lopez Alvarez from 1992. When reserving its ruling on the state's motion in limine regarding alternative perpetrator evidence, the court stated, defendant cannot merely show another person could have committed the crime. Rather, there must be evidence, direct or circumstantial, linking the third person to the actual perpetration of the crime. And it says, I don't know what this is about right here. Clifford S. Fishman and Ann Toomey McKenna. Jones on evidence from 2024. Okay. It says, see memorializing oral rulings on motions in limine from 4/18/25. That's my birthday. The state has listed blank as trial witnesses. And yeah, I guess like witnesses at trial were also in the alternate perpetrator evidence. That's sort of a interesting clue right there. Right there. The state also has disclosed and labeled exhibits that it intends to use at trial, which include the names or actual video of these witnesses. These exhibits include, so these perpetrators are already on video somewhere. How interesting. Okay. Each of these alternate perpetrators identified by defendant and listed as witnesses by the state are more closely tied in knowledge, opportunity, and possible motive to the crime than Mr. Kohberger. All four of the alternate perpetrators are linked circumstantially or directly to the crime. To the crime itself or to the victims? Because there is honestly a difference. I wish we had some more information here. Moreover, given Mr. Kohberger's expert disclosures that more than one person committed the crimes, other evidence supports the defense theory that Mr. Kohberger is not the person and the crimes were committed by more than one person. Defendant's offer of proof in part arises from the state's motion in limine regarding alternate perpetrator evidence filed February 21st, 2025. On page 2 of that motion, the state argued, in this case, during the course of the investigation, literally thousands of tips regarding possible perpetrators were received by law enforcement. With the exception of information regarding the defendant, none of these tips were substantiated. None of the tips prior to his name being public were ever about him either. Let's keep that in mind. While it is true that there are thousands of tips, somewhere in the range, holy shit. I take my lazy comment back. Holy shit. That's wild. Holy shit. That's a lot. The state has chosen to present evidence of investigations into the specific named individuals in the conclusion that the state has ruled out these possible perpetrators. Hold on, my big kid's in here. Let me see what he needs. Okay. Let's see, where was I? Okay, right here. The state's purported diligence in ruling out possible perpetrators, especially those with close connections to the victims, is an issue that state is putting front and center at trial in its own case in chief. That's something else that they have on the second drop of documents that they want redacted and unsealed is both the defense and the state's case in chief. I cannot wait. Oh my God. I hope they're not too redacted. Going to annoy me. Mr. Kohberger has the right to confront this evidence. The state argues, oh, hold on. There's a footnote. Okay. The court cannot consider or weigh the strength of the state's conclusion that a suspect has been cleared in deciding if the defendant's evidence is admissible. So these are people that have already been deemed clear. Or at least, at least one of them is, I'm assuming. And then they cite Holmes versus South Carolina from 2006. Forensic evidence existed, but could still be refuted by third-party perpetrator evidence of a person in the neighborhood. It was reversible error to exclude it, which is what happened in this case. And so they're basically saying you excluding this is going to be a problem, and it's already been proven in this case that it already has been a problem in the past, is what I'm getting from that. The state argues that the evidence submitted in the offer of proof is inadmissible as explained above. Much of it the state seeks to admit in its case in chief. More importantly, in Chambers versus Mississippi, the United States Supreme Court held that a defendant's constitutional rights to a fair trial and to present a defense sometimes require admission of evidence of third-party culpability, even in the face of evidence rules that would exclude it. Hearsay may be admissible in such cases because of 6th and 14th Amendment rights to due process. To confront and cross-examine witnesses and to call witnesses is never precluded. And then this is this is like something in some sort of edition book. This doesn't even have like a title. US 284. Edition 2D2. You know what? Whatever. Something from 1973. Fairness and trustworthiness of the evidence are important. Mr. Kohberger's proffer includes details that allow this court to see that there is trustworthiness to his basis for naming 4 alternative perpetrators. The police reports and tips submitted as exhibits in the offer of proof are documents that provide basis to show a link to the case that is more than speculation and grounds that explain the subject of cross-examination or direct examination of witnesses. While the tips themselves may be inadmissible, they are evidence that this court must consider in determining if there is a link and more than mere speculation. When evaluating alternative perpetrator evidence for case link or nexus, some courts demonstrate a willingness to admit purely circumstantial evidence that a third party committed the crime. U.S. versus Stever from 2010. Some courts hold that even when the state's evidence is purely circumstantial, the third party culpability must clearly point to a specific third party, i.e., some act connecting the alternate suspect to the crime. People versus Salazar from 2012 in Colorado. State versus Clark, Washington, 2nd Division, 1995. Then it says in Jones versus Wood from 2000. Thought Boomy was waking up. The 9th Circuit noted that the evidence at Jones' murder trial was primarily circumstantial in nature and concluded that the state trial judge erred in excluding Jones's circumstantial evidence that an alternate suspect committed the crime. Whether direct or circumstantial, all of the alternate perpetrator evidence proffered by Mr. Kohberger has both specificity of person and connection to the crime. With respect to redacted as hell. Damn. That is not a thorough investigation. That is not suspect elimination, as the state argues. So I'm guessing there's something here about like somebody that was maybe cleared and like a reason why they shouldn't have been. Mr. Kohberger did not produce these suspects. The state did, and in some instances, continued to investigate them or simply stopped their investigation, ignoring the evidence that there was more than one perpetrator. This is an interesting ass statement. And the most interesting part is this: in some instances, continue to investigate them. Like to the day that this shit was written, they're still investigating things. Interesting sentence. Prosecutor Bill Thompson said he could not rule out 2 perpetrators from the very beginning. Oh. There's an article. Is it going to actually like open to the right thing, or is it going to give me a problem? Okay, let's take a look at this. Police may be looking for more than one suspect in Idaho college slangs, prosecutor says. When was this? 11/17, 2022. So she's holding his own words against him. Let's take a look at what this article says. Can you guys see this? Okay, not really. Hold on now. Yeah, that's better. Let's see what he had to say back on November 17th, 2022. What article? Who wrote this? NBC? Yeah, I remember this right here. Let's just, you know what? Let's just see what old Billy Boy had to say back in the day. This is an old one. Let's listen.
By Latah County Prosecutor Bill Thompson. Mr. Thompson, good morning to you.
Yeah.
Good morning.
Police there have called this a targeted, isolated attack. Are investigators looking for a particular suspect or suspects this morning?
At this point, the investigators are looking at all possibilities. They don't have a specific suspect. They're continuing to work on that.
Do you believe that whomever did this is still at large?
Yes, we have no one in custody, and the police have been unable to identify who's responsible for these homicides.
Why would you ask if the person is still at large if your ass hadn't heard anything about an arrest? Okay.
Is it possible there's more than one suspect?
It certainly is possible. That's the purpose of the investigation. That's why we're really hoping for any information from the public that can help the investigators recreate everyone's activities Saturday night and early Sunday morning, and hopefully give them the leads, the information to identify who did this.
There's so many things about this case that are so hard to put together. Veteran police officers who arrived at the scene said it was one of the most horrific and gruesome scenes that they had ever seen. Yet somehow there were two roommates who were in the house who apparently didn't hear anything. What are the red flags you have there? And are those roommates considered persons of interest?
Of course not.
Well, anybody who might have
They're blonde,
knowledge
little
is
pretty
considered
girls.
persons of interest at this point. As far as suspects, I don't believe so. The investigators.
There's no way that by the 17th, yo ass don't know how much those girls have already lied to you over the past 4-ish days. How do y'all not have their phone information on the 17th? All you got to do is look at it, like open their freaking phone and see it. And if it's all gone and the forensic download shows things that were deleted, then you coming out here and saying this is wild.
Continue to work hard, trying to interview everyone who might have any information, and hopefully figure out and identify what occurred and why and who's responsible.
As we understand the timeline, and we recognize that this is an investigation very much ongoing, the four came home, early in the morning, Sunday morning, let's say 1:45, 2 o'clock in the morning, something like that. The 911 call didn't come until midday the next day. Does that raise any red flags for you? How do you explain that?
I think the investigators are trying to ascertain why there was a delay and what actually occurred, what was heard. That's a question that's still out there, and I know they're working on that. We're trying to assist them as much as possible with obtaining search warrants for data and cell records and social media and anything that might help.
Do you know who called 911? Can you reveal who reported this?
I can't reveal who.
I never understood that. Why? Why could y'all from the very jump not tell us who actually dialed 911? It doesn't matter that they played hot potato with the damn phone. Why couldn't they tell us straight at the very beginning? Who? Why is that such a freaking secret? Ignorant.
Who made the 911 call? The police do know who made the 911 call, though.
Obviously, we don't know anything about motive, but the mayor did initially refer to this crime as a crime of passion. Why did he say that?
He got scolded for that, too.
I can't speak for Mayor Bethany. He, to my knowledge, there is nothing to indicate that this has been determined to be a crime of passion. We know it's just a horrible crime, and 4 young lives have been lost.
And finally, initially, investigators and the police had said the community has nothing to worry about. Now they've sort of said, well, of course we should be vigilant because there is a suspect or suspects still at large. What is your message to that community this morning?
Well, I think the fact of the matter is that whoever is responsible for these murders is still at large.
No shit.
The investigators do not know who that person is. From what they've told my office, they believe that this was what they call a targeted attack and not just a random act of violence. And I think they tried to communicate that, but obviously that communication didn't work very well. It's unfortunate for any confusion in the community. People just need to be vigilant and help us however they can. We hope that we can identify who's responsible and get them off the streets as soon as we can.
We're sure your officers and prosecutors are working hard there. Thank you so much.
That's it. Yeah, it's just like a passing by statement. I mean, I see why they used it. But we also have the defense claiming that they have an expert, which I can't wait for that stuff to come out. Like, I want the expert opinion shit, like the DNA one that we read the other day from the state's like additional expert that excluded Kohberger completely from the fingernail clippings from Maddie's left hand. I want that stuff more than like anything else for everything, for literally everything, but especially the weapon one and the cleaning one, because there's apparently proof that the defense has of more than one weapon, which a lot of people already assume because of the way that Kaylee ended up. And then for there being direct and indirect evidence of a cleanup within that 8-hour time frame. I want to see that stuff. I want to see what these experts have to say about that kind of thing. Okay. Okay, this also goes on to say, Mr. Kohberger's offer of proof was not an exhaustive list of all the evidence disclosed in this case that points to the 4 alternate perpetrators. In fact, the state's opposition disclosed, and then a bunch of shit redacted, by listing these alternate perpetrators' names on their witness list and by listing various exhibits on their exhibit list which pertain to these individuals. The state has opened the door for Mr. Kohberger to confront this evidence and cross-examine. Is this about Molly? Is this about Molly? Because everything with her is sus as shit. Don't know where you're going. Suddenly you got a dog. You have no idea where you're supposed to be. You're walking around on the camera. You're a freaking felon. Like all kinds of stuff. So I wonder if this has something to do with Molly. Because remember again, when the MPD documents came out and they had gone in, was it MPD or Pullman? I honestly can't remember which one. But there's a list of K-Bar purchases. And one of them is in Pullman. And the initials are MM. And I instantly thought, holy shit, is that Molly buying a K-Bar? Because that'd be wild. Wouldn't that be so freaking wild? But again, it was just initials. So I guess we'll hopefully find out maybe one day. Mr. Kohberger suspects that the state has listed the 4 alternate suspects as a ruse to make it look as if they will put the 4 males on the stand to identify their involvement. Okay, well, that answered my question. It doesn't have anything to do with Molly. Okay. These witnesses must be confronted, and therefore, if the state seeks not to call them to the stand, but instead uses lab reports to portray elimination, the door is opened to confront that evidence, and Mr. Kohberger should be allowed to call the alternate perpetrators and other witnesses to show their connection to the crime. How each piece of evidence becomes admissible at trial depends on how the state offers it, triggering Mr. Kohberger's right to confront such evidence. Mr. Kohberger must be allowed to develop this evidence, and a ruling excluding or limiting this area of inquiry at this point would be premature. The United States Supreme Court ruling in Chambers allows for the admission of the evidence. The state agrees at a minimum to this confrontation in its objection. This court should allow Mr. Kohberger to present alternate perpetrator evidence. So what I'm getting from this is that everybody in the documentation, doesn't this not like take away the fact that Brent Kopacka was part of this? Let's like stop for a second. Let's stop for a second. Steve Goncalves, we already know he lies all the time. Okay. I don't really care. All right. I understand they lost a daughter. If you're paying attention to the facts here, you've already noticed he lies constantly. Okay. They wrote a whole thing talking about how, like on Facebook, the day of all this shit going down, they wrote an entire thing about how there's a veteran involved in the alternate perpetrator evidence, right? Then he went out in front of everybody in the courthouse and went dumb, yelling and screaming about a veteran being part of the alternate perpetrator evidence. Brent Kopacka is dead. He can't be on the state's witness list. So that takes him out of the running and makes Steve Goncalves look like even more of a liar about something. Unless the state said something stupid to him. Because honestly, I don't even know anymore. All I know is that Brent Kopacka is dead. So he can't be one of the ones in this document. That eliminates him. That eliminates him. That's interesting. So who are these people then? You got to take him out of it. Okay. These witnesses must be confronted, and therefore, if the state seeks not to call them to the stand, but uses lab reports to portray elimination, the door is open to confront the evidence. And he should be allowed to call the alternate perpetrators and other witnesses to show their connection to the crime. Yeah, this is still matching the whole we're going to use the state's evidence against them thing that they've been doing this entire time. I want to know where he got that from, or if he just came out here to like rile up the public, because they do that a lot. They do that a lot. All right, let's see what's next. Okay. State's motion to amend the now that the alternate perpetrators are on the state's witness list, the state wants to amend their witness list? How convenient. That's all I'm getting from that. Holy shiitakes. I didn't know this was 32 pages. Holy shit. Okay. Let's see what this one's all about. This is the state. Permission to amend the state's witness list and to supplement previously filed expert disclosures by adding Dr. Christian Westring as a potential expert witness. That's the one that we already went over, where he went in further and further excluded Kohberger from the DNA in Maddie's fingernail clippings from this hand, from the left hand. The state makes this motion to add the above referenced witness to testify about an issue that the state believed had been resolved, namely, that defendant was found not to be a contributor to a DNA mixture found under one victim's fingernails. But it wasn't resolved because y'all wanted to play stupid. Y'all wanted to play ignorant. Y'all went in here arguing about the term inconclusive because the lab had to create their own guidelines and stipulations to follow because of the way that they test DNA, okay? Y'all didn't further the testing in order to make these inconclusive statements no longer valid, to make them to where they were definitive answers. Because all that is that, we don't know. We could probably figure it out, but we're too freaking lazy to do so. The defense had to take the information and further have it tested. That's information that they submitted themselves. So no, the state did not resolve this issue. The defense did. All the state did was go in and have somebody else do even more testing, probably trying to prove the defense wrong. But then lo and behold, he came out with the exact same results of complete exclusion. That's probably what happened here. That's just how I'm thinking that it happened here. The state proposed a stipulation to this effect, but defendant informed the state that he will not so stipulate because he prefers to present testimony about this fact. Thus, the state will likely need to call Dr. Christian Westring to testify about the DNA mixture so that the jury can understand the state's position and not be misled into believing that there is factual dispute where none exists. But it did exist until you decided to do this further testing. It should have been done a long time ago, like years ago. On February 24th, 2025, defendant filed a motion in limine regarding inconclusive data. This motion centered around a DNA mixture found under victim Maddie Mogen's fingernails, item 13.1, and the Idaho State Police Forensic Laboratory conclusion that it was inconclusive whether defendant was a contributor to this mixture. It should have never been left inconclusive, just like the other sample should have never been left unknown. Answer the entire question. There's no reason not to. As Dr. Westring explained in his affidavit, which see below, we've already gone over it. Maybe that's the majority of this, because then maybe I don't have to read the whole thing because we've already read it. Hopefully that's the case. That conclusion is a result of limitations imposed on ISP lab staff by certain internal policies. See, they had to do their own thing. But the state did not intend to argue or imply that defendant was a contributor to the DNA mixture, and it has maintained this position since the issue was first raised. Yeah, remember they said that they brought this up at the grand jury in order to basically do the defense a solid by saying, yeah, we have Maddie's left hand's fingernail clippings, DNA mixtures, and he was, inconclusive. Well, all that means is that the testing couldn't go farther enough and that there was still a possibility, is what that leads the jury to believe, what that leads a grand jury to believe. Obviously, look how we went. So leaving that word that way doesn't do what it's supposed to. And they know that. They know what they're doing whenever they play these little word games. Thus, the state retained Dr. Westring to review the DNA testing and the computational analysis of the data. In response to defendant's motion on April 7, 2025, the state filed an affidavit for Dr. Westring. In summary, Dr. Westring opined that there is no published standard that dictates how to determine analytical thresholds. 2, ISP Lab concluded that the analysis was inconclusive with regard to Bryan Kohberger in accordance with their published standard, which is different than the standard. This guy had to go in and be like, yeah, basically it's close enough, it's fine. But they had to do their own thing, which has always been a problem to me. But as long as like other experts that work in other things have been able to come in and been like, yeah, it's their own regulations for this reason and that reason and this reason and that reason, but it's close enough to the standard to where we don't have an issue, especially since further testing with similar programs that are conducted by both sides have the same results. So that's fine. Especially since now we've got both the state and the defense coming up again with the exact same result now that they've further tested stuff. Okay, this motion was heard by the court on April 9th, 2025. The court issued an order on April 18th, ruling that the defendant's motion was denied as moot, but it shouldn't have been, honestly. On May 9th, 2025, the state sent the following proposed stipulation of fact to the defense for their consideration. A DNA sample taken from underneath a fingernail. We were told it was fingernail clippings, meaning like they cut all 5 fingernails and did what they did, not just one. Okay, I really hope it's not just one. Because underneath a fingernail and fingernail clippings are wildly different things. Contained a mixture of DNA from 3 individual contributors. Maddie Mogen and Kaylee Goncalves were identified as 2 of the 3 contributors to the mixture. Defendant Bryan C. Kohberger was excluded as a contributor to the mixture. The proposed stipulation is attached as Exhibit S2. A month later, on Sunday, June 8th, 2025, the state emailed defense counsel regarding the proposed stipulation since the state had not received a response to the above proposal. On June 9th, 2025, defense counsel informed the state that they would not agree to the stipulation so that defendant could present testimony on the issue. Based on the above, it appears it may now become necessary for the state to call Dr. Westring as an expert witness in the state's case in chief to ensure that the jury understands the state's position that defendant is not a contributor to the DNA mixture and always understands why the ISP lab's reported results were described as inconclusive. If the state cannot call Dr. Westring, the jury would be left with the misperception that the state thought to suggest that defendant could be a contributor to the DNA mixture. When you stop it at inconclusive until you get called out, that's exactly what you're insinuating. Quit playing, which has never been its intent and would raise a variety of concerns under Idaho Rule of Evidence 403. Of course you know which rule to cite. Quit playing, Xana. We know exactly what you're doing. Consequently, the state respectfully seeks the court's permission to amend the state's witness list to add Dr. Westring and to file an expert disclosure to incorporate Dr. Westring's already disclosed analysis and opinions. Yep. This is the part that we read that was posted separately. Is there anything additional? No. So if you guys missed this one and want to listen to me read it out loud and go over it, it's in the live for like Docs Unsealed Part 1. What I'm going to end up doing in this one is cutting out Bethany's interview. I'm going to post that one separately, edit this one to where it starts never going over the documents, and I'm going to change the thumbnail to Docs Unsealed Part 2 to try to keep them in order the way that we've been trying to keep all of the documents in order as they come to us. I'll do that tomorrow or maybe tonight, depending on how long it takes for YouTube to process it, because it won't let me edit anything until it's done processing it all the way. I think we read this one already. No, this isn't the same one. By what? What does this freaking say? Okay, so this is an order granting defense expert. His handwriting is like a doctor's. Jeebus. The judges. It's hard to freaking read. Okay. Order granting defense expert analysis of evidence. The court having before it the motion for independent analysis of evidence and good cause appearing now therefore. It is hereby ordered that the aforementioned evidence shall be made available to defense expert blank by the Moscow Police Department and or other agency in possession of the same for independent testing and review by an independent testing agency. It is further ordered that blank shall, at the defense counsel's expense, be allowed to conduct the independent testing of the evidence, specifically the Acer laptop and Samsung phone belonging to Bryan Kohberger. Okay, so now we've gone from DNA to electronics. It is further ordered that the chain of custody shall be maintained on the evidence at all time. Moscow Police Department shall hand deliver and or ship the evidence via FedEx directly to blank, who will ship the evidence via FedEx back to Moscow Police Department upon completion of testing. The evidence should be shipped to attention blank. Is this whenever they're supposed to have sent this stuff off to the Barnharts? Because this is like June, and they were being mentioned, I think, before that. So I don't know who this is. It is further ordered that, oh wait, no, this is being like to the bill of the defense. So it's not the Barnharts. I wonder who this is. Okay. It is further ordered that upon completion of testing by blank is to immediately notify ANSI Taylor to arrange for transfer of the evidence back to the MPD. It is further ordered that the results of the testing shall be considered work product of Mr. Kohberger and or his attorney, and said results shall be submitted solely to the office of Ann Taylor. Let's try to see if they had somebody's business or something on here. Okay, so this is his electronics being sent off to somebody that the defense wanted. You would think that stuff would have been done a long time ago. Why is the defense just now sending his electronics off? They're just now sending off electronics and just now getting information about Molly. I'm not comprehending like how they were efficient. Jeez. Okay. State's objection to defendant's offer of proof regarding alternate perpetrators and defendant's evidence in support of offer of proof. Okay, so this is a state. Yeah, this is the state's document about the alternate perpetrator stuff. I hate how these are so like all over the place. Okay. Comes now the state of Idaho by and through the Latell County prosecuting attorney and objects to the defendant's May 14th, 2025 offer of proof regarding alternate perpetrators and May 23rd, 2025 evidence in support of offer of proof regarding alternate perpetrators. This isn't even, is it? Okay. On April 18th, 2025, this court entered its order memorializing oral rulings on motions in limine, which included the state's motions in limine to prohibit the defense from offering alternate perpetrator evidence. In that order at page 6, the court directed that the defendant must present offers of proof no later than May 14th, 2025, so the matter can be addressed at the pretrial conference, which was conference. You heard that? Conference, which was scheduled for May 15th, 2025. The court recognized the Idaho Supreme Court's decision in State versus Meister from 2009, which held that mere inferences that another person could have committed the crime will most likely not be relevant, and if relevant, will still be subject to the limitation provisions of IRE 403. The court correctly noted that, after all, defendant cannot merely show another person could have committed the crime. Rather, there must be evidence, direct or circumstantial, linking the third person to the actual perpetrator of the crime. Linking the third person? Oh, citing Jones on evidence. Okay, see, somebody is not going to read all of that and be like, what you mean? Jeez, I hate the way that they put those citations in there and like try to just like mold it into like what we're supposed to be thinking about the case itself. It's absolutely wild. Okay. The defendant subsequently filed his offer of proof regarding alternate perpetrators on May 14th, 2025. At the pre-trial conference held on May 15th, the court directed the defendant to submit actual evidence to support his alternate perpetrator allegations, stating that the defendant's May 14th proffer contained allegations that were fairly objectionable. The defendant subsequently filed his evidence in support of offer of proof regarding alternate perpetrators on May 23rd, 2025, yet the defendant's proffered evidence is substantially no different than what the defendant alleged in his May 14th, 2025 alternate perpetrator documentation, with the exception of an blank. Starts with a vowel. It's pretty much all we can tell. It appears that, in reality, the defendant merely wants to cross-examine various states' witnesses as opposed to trying to make a case of an alternative perpetrator. While the defendant certainly has the prerogative to cross-examine states' witnesses, he cannot speculate that a third party committed the crimes with which the defendant is charged. This is the essence of the limitations and requirements related to alternate perpetrators. It remains the state's position that any attempt by the defendant to offer or argue an alternate perpetrator theory without evidence, specifically connecting persons other than the defendant to the homicides, would do nothing more than mislead and confuse the jury and would also result in undue delay. You mean the way that your inconclusive stuff confused the jury? Funny how now you complain. Waste of time and needless presentation of cumulative evidence and unfair prejudice to the state under IRE 403. Turning next to the four individuals the defendant wishes to argue as alternate perpetrators, the state addresses each in turn. As discussed below, the court should preclude alternate perpetrator evidence as to each because the defendant has not provided admissible evidence linking them to the homicides as required under Meister. And this is a person's name. The defendant first proffers all of this blankety blank blank blank. Proximity to two of the victims hours before the homicides without something else later that night is not probative evidence as inexcludable under Idaho Rules of Evidence 403, particularly looking at blank. Blankety blank blank blank. Maybe is this Jack Showalter? Maybe. Is this Jack Showalter? Quite possibly, I guess. And then a bunch of blanks. A bunch of blanks. Okay. The defendant next points to 3 lab reports, which merely reflect that as part of blank cooperation with the investigators, he voluntarily submitted a DNA sample and fingerprints. Tellingly, the defendant fails to note that the ISP forensic lab eliminated blank's DNA from the crime scene. I want to know who this is, though. I mean, if they're innocent, then let us know what's going on anyway. Jesus Christ, how hard would it be? It wouldn't cause any problems. I mean, honestly, it probably would cause problems because people are stupid. But I just, pure curiosity. If you really are just innocent and this is something that, you got drug into, then tell your story. Let's hear it. Why not? Blank DNA was not found on the knife sheath strap on which DNA was found that was matched to the defendant or in the DNA mixture found on the back of the sheath. See States Exhibit S1, ISP Forensic DNA Lab Report number 4. ISP Lab Report 7 excludes blank's DNA from the swab taken in Xana Kernodle's room from the DNA found under Miss Mogen's fingernails. See Exhibit for Lab number 7. Lab Report number 7. ISP Lab Report 13 excludes blank's DNA from the samples from the fingernails from all of the other victims, as well as swabs taken above the stairwell at the residence, the upper floor banister, and the bottom of the handrail. Oh, so there's more. We have the stairwell itself, the banister from the upper floor, and then the bottom of the handrail. The handrail must be the one from the first to the second floor. See States Lab Report number 13. ISP Lab Report 26 excludes blank's DNA from a sample taken on the north wall of the stairwell at the residence and another sample taken from the half wall at the residence. See Lab Report number 26. Lab number 31 excludes blank DNA from the sample taken from the door of Miss Mogen's bedroom. See States Exhibit Lab Report number 31. Well, his DNA is excluded from everything here too, except for the button. This is saying the strap or whatever, but it's supposed to have been the button. everything else is like the suspect as well. The defendant next submits 3 law enforcement investigation reports, blank. First, these reports and their contents are hearsay. That said, all they demonstrate is that blank affirmatively reached out to law enforcement investigators and voluntarily cooperated with them, including providing his DNA. I feel like that's Showalter. Defendant speculation that this somehow suggests culpability is without foundation. I feel like that's Showalter. I really do. The balance of the defendant's submissions are comprised for references and just blankety blank blank blank. In sum, the state respectfully submits that the defendant's submissions regarding blank do not even rise to the level of mere inferences that he could have committed the crimes, much less evidence, direct or circumstantial, linking him to the actual perpetration of the crimes. And this is page 6 from the April 18th order. The defendant's submission continue with regard to blank and are inadequate in the same ways as discussed with respect to blank. Blank's DNA was excluded from the mixtures from the back of the sheath, the sample from Xana Kernodle's bedroom, the samples found under Miss Mogen's fingernails, and from the fingernails from all the other victims, swabs taken from above the stairwell at the residence, the upper floor banister, and the bottom of the handrail at the scene of the crime. Okay, but whose blood is it? It's not Kohberger's, and it's not all these other people's. Whose is it? Why do we not have those answers? Why do they just not care? Blank's DNA was also excluded from the swabs of the north stairwell wall and half wall, see lab report number 26, and from Miss Mogen's bedroom door, see state's exhibit. And remember Steve Goncalves in the interview that he did with Grace was like, there was no blood on Maddie's door. Yes, there was, like 3 different spots. Two at least, but I'm pretty positive 3. Defendant next alleges that Blank's alibi as to his whereabouts and activities on the early morning of November 13th cannot be corroborated. Offer of proof at page 4. This is incorrect. And of course, they've got it all freaking blanked out. If whoever this person's alibi like checks out, then why can't we know it? You know what I mean? Like if it checks out, you've got all the proof. Let us know who was being put under the bus. I mean, damn. Defendant next suggests that blank and a bunch of redactions. This is not probative of a connection between blank and the crimes. As he did with blank, defendant then cites many tips that blank should be considered a suspect. This is a short ass name. Or is this he? I guess it could say she. Who freaking knows, honestly? Yet there is no evidence of any tip, which would be hearsay anyway, in the defendant's filings other than statements attributed to blank. The balance of the defendant's submissions regarding blank, as with the others, are largely hearsay and are at best mere inferences that blank could have committed the crimes. There is no evidence, direct or circumstantial, linking blank to the actual perpetration of the crime. Defendant next refers to blank. That's a long name. Or is it like somebody's something, comma, the name? You know what I mean? As with blank, it's still just really long. DNA was excluded from the strap at the back of the knife sheath. See State's Exhibit S1, ISP Forensic DNA Lab, Report number 4. In addition, blank was excluded from the samples taken from the victim's fingernails, bunch more blanks, from the swabs above the stairwell, the upper floor banister, and the bottom of the handrail. Lab Report 26 excludes blank from the swab taken of the north wall stairwell of the crime scene and the half wall of the crime scene. Lab Report number 26. Yeah, I said that already. Number 31 excludes blank's DNA from the sample taken from Miss Mogen's bedroom door. So I'm going to assume that the blood on the bedroom door is not the victim's. Because why would they be testing it against the blood on the bedroom door if it matched Maddie or if it matched Kaylee? You know what I mean? Like if it was dripping off of the weapon as the person was walking by and something happened, or if while they were like flinging the damn knife around, if it's not Maddie's or Kaylee's, then it must be some males, not Bryan's. So why isn't that being taken more seriously here? You got blood on the door that you can't match to anything, and that's not something that you would want to solve regardless of where it points. That's what this sounds like to me. Yeah, it means it's male and it doesn't match Kohberger. That's exactly what it means, in my opinion. The defendant notes that blank was familiar with the victim and their residence and lived nearby. Aside from the fact that blank, the other observations of proximity are not unique to blank. Indeed, it appears that there were numerous people who were familiar not only with the victims, but also with the 1122 King Road residents. Defendant also makes note that all this blankness. This too is not suspicious. Well, we don't know that, do we? The defendant also alleges a bunch of blankness. Holy shit. Blank was fully cooperative with the investigators, providing DNA and consenting, all these things that we can't know about. Why can't we know about any of this? Consenting to what? A phone download? Fingerprints? Why are we not allowed to see what this person consented to? Is it something that leads to think that other things happen that we're not being told about? Because why else are we not showing this? I mean, pretty much everybody that was tested or that was a male that was involved in this was like phone stuff, fingerprints, blood, let's go. Or DNA, let's go. Why can't we see this? Okay. Again, the defendant's allegations do not rise to the level of even an inference that blank committed the murders, much less constitute evidence, direct or circumstantial, linking blank to the actual perpetration of the crime. Okay. Finally, the defendant submits blank as an alternate perpetrator. The defendant attachments clearly reflect that blank was cooperative and voluntarily submitted a DNA sample. Lab reports 13 and 31 exclude blank's DNA from any of the samples from the crime scene or the victims, inconclusive as to the sample from Miss Mogen's fingernails. So this person was tested. Is this Cole? I wonder if this is Cole. It says to see lab report 13 and 31. They said that already. ISP lab report 26 also excluded blank's DNA from the samples from the north wall of the stairwell at the scene, as well as the half wall at the scene. Blank's only possible connection to any of the victims was blank. This behavior is not probative of any role in the homicides and is also excludable under Rule 404. I wonder if this is Cole. Interesting. Defendant also alleges that blankety blank blank blank. Regardless, even if blank, this act does not provide any evidence of a connection to the crime, much less the type of evidence required under Meister. The balance of defendant's proffers regarding blank are largely hearsay, and some would be also precluded by IRE 403 and 04. More blanks. Perhaps the most obvious failure in defendant's proof is the fact that blank. Okay. Really? We can't even see this one? Come on now. Come on. Once again, the defendant's submissions do not even rise to the level of a mere inference that blank could have committed the homicides, much less evidence, direct or circumstantial, linking blank to the actual perpetration of the crime. In addition to the foregoing, none of the defendant's submissions even hint at any connection between these four individuals and the defendant himself. It doesn't point to what Steve Goncalves was stating either. So is he going to come out and address this? Probably not. Based on the undisputed evidence and what appears to be his theory of the case, the defendant likely will argue that the true killer or killers committed these crimes and also framed the defendant by placing his K-bar knife / sheath at the scene. What do you mean? The slash right here is a little odd. The slash right here is giving something it's not supposed to. But nothing in the defendant's submission points to any of the alternate perpetrators accomplishing this or having the motive or means to do it. Nor does the defendant connect any of them to a K-bar knife, whether the one the defendant purchased in March 2022 or another K-bar. Defendant submissions also do not connect any of the individuals to a Hyundai Elantra. Well, y'all weren't even looking for that car to begin with. homeboy. Conclusion. Based on the above, the state respectfully prays for an order from this court prohibiting the defendant from arguing an alternate perpetrator theory. The defendant is free to cross-examine these individuals if they are called by the state, but again, should be barred from suggesting or arguing that any of them are alternate perpetrators of the homicides. So yeah. These were all people that were going to be called as witnesses by the state. Interesting. Here's the link to that one in case you guys want to try to figure out what the hell that one's all about. Okay. Let's see where we were. Is it this one? Okay, this has to do with his laptop. Did we read this one already? Because all this is doing is talking about FedEx this and FedEx that and this, that, and okay. I don't think, this is a different one, I think. Okay, so this is them requesting the court for an order allowing the independent testing. The other one that we read was basically like, yeah, go ahead and do it. This is, again, for the Acer laptop and the Samsung phone belonging to Kohberger. The items requested should have a continued chain of custody for Moscow Police Department. We do see it. Like, they have the chain of custody. I'll pull it up. It should be one of the next ones that come up. This item shall be hand-delivered or sent via FedEx shipping to blank and returned directly to Moscow PD through FedEx shipping. If either item of evidence is damaged or lost during the transportation of such items, the defense will stipulate to extractions done by the state and/or photographs of the items. Further, during such time as the items of evidence are in the possession or under the care and control of the defense, all items will be handled with care while preserving the items and maintaining chain of custody. Well, why is that something that you have to actually state? This motion is made on the grounds that Mr. Kohberger has a constitutional right to confront the state's evidence, conduct an independent investigation, and prepare and present his defense at his jury trial. I mean, all that should have been done already. I don't know why we're just now freaking talking about both sides doing testing and looking into things like that. That's absolutely insane that we got to this far in and they're just now trying to send shit off. Like, what? Okay. Comes now, State of Idaho, by and through the Latell County prosecuting attorney, and respectfully informs the court the state does not object to the defendant's motion for independent analysis. So the state was like, yeah, go do what you got to do. When it comes to the laptop and the phone, it should have been done already. It is wild. That is just so insane. Like, what? It's kind of like, should have been done a long time ago. Okay, so this is what this next one is going to show. It's going to be chain of custody for this stuff. This is for the 23rd supplemental request for discovery. Complete copy of the chain of custody of the Acer laptop and the Samsung phone belonging to Kohberger. Copy of image QPH5, reference an FBI report, evidence barcode. I wonder what that is. Maybe just a picture of like how they found it, maybe. Copy of all of the raw data, records, handwritten notes, and forms used by Dr. Gage in the evaluation of Bryan Kohberger. The defense is asking that these materials be sent directly to Dr. Rachel Orr. Okay, so this has nothing to do with his electronics. This is about his evaluations and stuff that they did. Okay, this should be the discovery. Okay, I'm not the discovery, but the chain of custody. Okay. So, oh, too big. Okay, Exhibit S1, State's response to defendant's 23rd supplemental request for discovery, filed 6/2/2025. Exhibit V. The state's responses are provided in blue. The state will continue to supplement its discovery responses in additional information as additional information is received. Boomer's tail is like wagging in his sleep. I'm guessing he's having a good dream. Complete copy of the chain of custody of the Acer laptop and Samsung phone belonging to Bryan Kohberger. The state has previously complied with this request as follows. The Acer laptop is identified as MPD item 905 and MPD property number 24M1047. Defendant was provided photographs. Okay. Depicting the chain of custody for this item on August 16th, 2024. That's a long time. The chain of custody for this item is as follows. The Acer laptop was seized from room K at 119 Lambsdon Drive in Albrightsville, Pennsylvania on December 30th, 2022 by FBI Schreier and Maslin. This was probably Brian's room. They've mentioned room K. I'm going to just assume it's his room. I don't really know, though, but that's probably what it is. The above item was turned over to Special Agent Tanzola prior to the conclusion of the search. Tanzola transported the item to the Philadelphia Regional Computer Forensic Laboratory Evidence Control Room. On February 11th, 2023, S.A. Tanzola took possession of the above item from the PHRCFL evidence room. This item was then hand-delivered to Detective Lawrence Mowry on February 14th, 2023 at the Moscow Forensic Lab, probably via airplane. Wouldn't surprise me. On July 22nd, 2024, Detective Mowry transferred the above item, which was secured in the MPD forensic lab, and booked the item into evidence with the evidence custodian at MPD. So they got it on February 14th, 2023, and didn't book it until July 22nd, 2024. I mean, it was just like in the lab the whole time. Did they do anything with it the whole time? It just sat there. Bryan Kohberger's Samsung phone is MPD item 902 with property number 24M1044. Defendant was provided photographs depicting the chain of custody for this item on August 16th, 2024. And chain of custody is as follows. Kohberger's cell phone was seized from room M. Oh, okay. Maybe I was wrong. You think room M would be his room. Well, which room is room K? Hopefully they give us a diagram of how they're like depicting all the rooms. At 119 Lambsdon Drive in Albrightsville, Pennsylvania on December 30th by Schreier and Moran. The above item was turned over to Tanzola prior to the conclusion of the search. Tanzola transported the item to the Philadelphia Regional Computer Forensic Laboratory Evidence Control Room. On February 11th, 2023, Tanzola took possession of the item and it was hand-delivered to Lawrence Mowry, February 14th, 2023. On July 22nd, 2024, it was then transferred to the MPD lab. So same times, same everything. Okay, copy of images QPH5_1. Referenced in FBI report 25-114. The state has previously complied with this request. This is an image of Bryan Kohberger's Acer laptop's hard drive. This information was provided on April 4th, 2024 on the server provided to defense. It can be found in the following path. And it was also provided as AV000905 on May 14th, 2024. Kohberger computer devices, Kohberger laptop images. That's like that file. And then this is the Pennsylvania Computer Forensic Lab report states that an image of the above was provided to the state subject matter experts. Copy of all the raw data records, handwritten notes, and forms used by Dr. Gage in the evaluation of Bryan Kohberger. The defense is asking that these materials be sent directly to Dr. Rachel Orr. A copy of the raw data from Dr. Gage was requested on May 29th, 2025. Dr. Gage sent the raw data directly to Dr. Orr pursuant to applicable professional ethical standards on May 30th, 2025. The state has requested the balance of this discovery request, i.e. records, handwritten notes, and forms used from Dr. Gage. The state will provide upon receipt. Okay. Oh, I just read that one. Is that it? That looks to be it. That looks to be it. Let's see if there's anything in the case summary that's different. We still have the second order. And this case summary hasn't actually even been updated since 9/3/25. So that's kind of crazy because it should now be reflecting like all these new ones. I guess technically it does because we've already seen that all of these were in there. We just knew that we couldn't see them. Okay. Well, that looks to be it. I'm going to go ahead and roll this one out real quick. Please do not forget to leave a like on your way out and subscribe to the channel if you are not subscribed already. Okay, you guys. See y'all.